Hey, I'm Patrick Stegall, criminal defense attorney in Memphis. A lot of my practice is dedicated to defending criminal cases in federal courts, and I want to talk today about how federal court works generally and how federal cases are different in some ways than state cases. You know, in the justice system, in the law, we have federal law and state law, okay? State law obviously is going to apply to whatever state you're in. Federal law, on the other hand, applies everywhere, right? It's nationwide. It's the federal government. So these are federal laws that will apply pretty much wherever you are in the United States. I mean, generally, federal cases, federal court cases are more serious than state cases. They can be. Things are just different in federal court. It's more serious, okay? There's more preparation that needs to be put into a case, and the stakes can be higher. A lot of federal crimes carry significant punishment, years, maybe decades in prison if convicted. And the way federal cases work generally, if you're charged with a case in federal court, it's not like they just see you committing a crime and then go and arrest you and take you to court. That's generally how it works, or how it can work in a lot of state cases. That's not how it works in the federal court. If you've been charged federally, chances are they were watching you for a while. That's how they do it in federal court. They will build their case. Law enforcement agencies at the federal level, the FBI, ATF, Drug Enforcement Administration, Secret Service. Okay, these are federal law enforcement agencies. They will typically build their case for months, maybe years, against their subject, gathering information. They get wiretaps to record phone conversations and intercept text messages. They use confidential informants to conduct drug transactions. They will get subpoenas for phone records or bank records, okay? There's a lot of different ways that these law enforcement agencies will use to build their case, and then they will take that to the prosecutor, to the United States attorney, submit it to them for their review, and then again, it then gets submitted to a grand jury. And once it goes to grand jury, the subject, the defendant, gets indicted. An indictment is simply notice of the charges. It's formal notice of the charges. And at that point, that person can get picked up. They get picked up by U.S. Marshals or whatever law enforcement agency, and then they're brought to federal court. And from there, the case proceeds more or less how a case would proceed through any other court, like through a state court. But again, in federal court, everything is just a little more detailed, and the stakes are higher, because it's not like they saw somebody committing a crime and arrested them right then and there. Again, this investigation was probably going on for months. All right. So when you get to federal court, you're looking at a lot more evidence, and as I mentioned, time, punishment. Okay, punishment can be greater, and in federal court they use months, not years. So you might be looking at 48 months, 60 months, 120 months, or something like that. Okay. And that's something that once you get into a case federally and you work with your attorney, you see, you kind of figure out where you might fall in what they call the guidelines, because it's when you're sentencing, when a person's been charged in a federal court and you're thinking, well, how much punishment, how much time am I looking at? You go by guidelines, guideline ranges. It's all part of the federal sentencing guidelines. And you have to know this stuff. You have to have an attorney who knows what they're doing, and figure out, where you might fall in a worst case scenario, where you might fall in a more reasonable scenario. And another thing about federal court is generally when I negotiate with a prosecutor, with the assistant United States attorney on that case, we don't just come up with a deal. Like if we're trying to work out a deal, it's not like, okay, I'll give your guy 4 years and boom, we get 4 years. It just doesn't work that simply in federal court. We might think, okay, maybe 4 years is what we'll get, or 48 months, because we typically use months in the federal system. You might think, yeah, I've got a shot. Maybe you might get 48 months, but you might get more, you might get less. Very rarely will prosecutors just give you an offer of this much time. Like, if you plead guilty, this is what you're going to get. You just don't know. You have to have a sentencing hearing for that. I think in my career, one time on a federal case, did myself and the federal prosecutor work out a deal where it was an exact amount of time. It was 120 months, 10 years for my client. It was a case involving a significant distribution of narcotics, methamphetamine, and we were able to basically, it was a 10-year mandatory minimum, and the prosecutor agreed to cap it at no more than 10 years. If my client pleads guilty, then he'll get 10 years and nothing more, and that's what we'll recommend to the judge. That's the only time that I've gotten an exact amount of time in an agreed upon case, in a settlement. Most of the time, all you can do is come up with a range. Well, you might get this much, you might get that much, and it's up to the judge. And judges in federal cases, when it comes to sentencing a defendant, have wide discretion. They have a great amount of discretion to sentence you, on the high end, in the middle, on the low end, and that's where you have your sentencing hearing, and that's where you need a good attorney who's going to put forth the best case for you in front of the judge to get you the lowest sentence possible, because judges will consider all kinds of factors, mitigating factors in your defense, your upbringing, your work history, your involvement in the community, family ties and family relations, people who can write letters for you. Judges love that. Judges love reading character letters from people who know you, and judges will review all of this in making the sentence. So they've got, like I said, the judge has a lot of discretion, and it's up to you and your attorney to put forth the best case to lobby the judge for the lowest sentence possible. So in federal cases, there's just a lot of detail that needs to be looked at and delved into when you're working the case and going through the evidence and seeing what can the government prove. And generally, again, they've probably been watching you for months, so they've probably got a pretty solid case. And then if you opt to enter what's called a change of plea, basically plead guilty to the charge, you then have a sentencing hearing, but you don't have a sentencing hearing the next day or the next week. It's typically 3 months later. It takes 90 days to prepare for a sentencing hearing after your change of plea. And then in that time, you're working with your attorney to, again, try to get the lowest sentence possible, figure out where in the guidelines you're going to fall. And when I say guidelines, it depends on the crime. For example, in a drug crime, it depends on the type of drug and the weight and the amount of it. How many grams or how many ounces of controlled substance are we talking about? The more weight there is, then the higher possible sentence you might get. Another factor that judges look at is your criminal history. If you have what they call criminal history points, if you have a large number of convictions, it can be for misdemeanors, felonies, state courts, the judge will look at that and that'll get you a higher sentence. If you have no criminal history points, then you're in pretty good shape. Probation, is that possible in federal cases? Yes, it's hard to get. It's hard to get probation. Again, in my career, I think I've been able to put one client on probation in a case in federal court. It was a lady involved in a gun transaction, and she was basically there and was an accomplice to a transaction, an illegal transaction involving a gun, and she got a couple of years probation. But if you're facing a crime in federal court where it's going to be more than 24 or 30 or 36 months, you're probably not going to get probation. There's got to be something on the low end. You got to be a first-time offender. That's the thing about federal court. People get time. They get hard time, and you serve it all. There's no parole in the federal system, and there's no expunging a case. Expunging a conviction isn't possible in federal courts. So it's serious. Federal court's the big leagues. Okay, in trials, you can try a case, and the procedure is more or less about how it would go in state court in a trial. If you go to trial, you set your trial date, you show up, you pick your jury first, and then you put on your proof, and it could be, depending on how complex the case is, it could be a few days, it could be a couple of weeks of trial. Okay, The procedure is more or less how you would go about that on a state case. But again, everything is just at a higher level when it's in federal court. A lot of times people, get charged federally and then they get released right after they're charged. They may have their initial appearance in front of the magistrate, and if it's, if they have a minimal criminal record and it's not, a highly serious offense involving, serious allegations, the judge may give them pretrial release, which means you're released without having to pay a bond. Here in the Western District of Tennessee in Memphis, judges will frequently do that for those types of defendants. If you're seriously involved in a complex drug transaction, or there were guns involved, there's some allegation of violence, you're probably not going to get a bond. You're probably going to get held without bond pending trial. But sometimes clients are released if I can show the judge that they were, involved, but minimally involved in maybe a drug distribution network, or if it's a client with a gun charge but they don't have a serious criminal record, may be able to petition the judge to release, give you pretrial release, or basically release on recognizance. Okay, so then you're out, which is good. So you can go back to your life, you can work, be with your family, and all those things while your case is going on. But if you end up, pleading, doing a change of plea, or going to trial and getting convicted, and then you get sentenced to time. If you get, say, 48, 60 months or something like that, you got to turn yourself back in and serve that time. That's tough. That's tough when you're out, when you've been out for a year or more while your case is going on, and you're trying to just live your life normally and do the best you can, but then you end up getting sentenced to however many months of time, and you got to go serve that. You got to go turn yourself in at a federal detention center. But I mean, that's how it goes in federal court. So if you're facing a federal charge, you need an attorney who knows the federal system, who has experience in those kinds of cases. I represent these kinds of cases here in the Western District in Memphis, and in Mississippi and Arkansas, where I'm also licensed. Thanks for watching.